So thus far, we have kind of started the process with what is a definition of real estate. And then we work through how do we own real estate. And then we work through how do we describe real estate and how do we transfer real estate. Now we're at the point in time where we need to start to understand the contracts that go along with a real estate transaction. And the contracts are super important to what we do. Does that make sense for you guys? Obviously, I think we all understand that ultimately, as a real estate broker, we're going to have a lot of involvement with contracts. One of the things I like to caution you about before we even get to a jumping off point here is this idea that you're not an attorney. This is not a pre-law class. Even though sometimes I know it can feel that way, it's not pre-law. And so we always have to remind ourselves where the line in the sand is for when we've gone too far with legal advice. And we're really always very cautious about that when we're talking about contracts. So we want you to learn this contract language. We want you to learn what the types of contracts are and what it means for a contract to be enforceable in a court of law. But ultimately, where are you going to direct contract questions, do you think? Other than just basic sort of structural questions, where do you think ultimately you're going to direct those questions once you're out in the real world practicing as a broker? To an attorney, exactly. As Tina said, to an attorney. And that's where you want to go. That's where you want to go. So we need to talk about what is a contract. A contract is a legally enforceable set of promises between legally competent parties. Now, that's the fancy definition. We're going to break that down a lot in the next half hour or so, because we're going to talk about what it means to have legally competent parties. We're going to talk about what it means to be legally enforceable. We use that word legal a lot. Legal. What does that bring to mind for you? I heard Emily say a judge. I heard Savon say the law. A judge. All those are good answers, because where do contracts ultimately matter most? In court. So everything in this chapter is really about what would happen if this contract ended up in court. If this set of promises ended up in a court of law, what would be the outcome? Would it be legally enforceable? And legally enforceable just means, would a judge agree that this is an agreement that has to be followed by these two parties? Now, I want to show you what we feel like sometimes as real estate brokers when we finally have somebody willing to sign a contract.
Where do I sign? I'll never see you again? Never. You realize this is my family land. Does it please you to rip out my ancestral roots? I was born and raised in a briar patch.
That's generally how we feel most of the time. You know, they just want us to get it done and get out of their faces. But that's all right. We do it anyway, and we love it anyway. So let's talk about some of the requirements of a contract. First of all, contracts have to be voluntary. You cannot force someone to enter into a contract. A contract is an agreement between those two parties. They have to have what we call a meeting of the minds. So a meeting of the minds really just means agreement. It's coming to an agreement, understanding that they both know what they're promising to do. And that's a really important part of the contracting process. Now, in that first definition you saw, it said it's a promise or set of promises between legally competent parties. So let's talk about what a legally competent party is. It's a fancy way of saying you have the ability to enter into a contract. Because somebody who's legally incompetent, guess what? They don't have the ability to enter into that agreement. So these are some examples of things that would make you legally incompetent. Number one, first and foremost, what do you think our contract party has to be? An adult. Tavon said they have to be an adult, and that is exactly right. That is the first requirement. So in North Carolina, that particular age is 18. It's called the age of majority. But what that means is that legally speaking, a person under the age of 18 can't be held responsible for a contract. Now let's talk about that for just a second here. Notice I didn't say that a person under the age of 18 could not enter into a contract. I said they couldn't be what? Held responsible. Exactly. They can't be held responsible. So can they enter into a contract? Yes, they can. No question about it. And since we're in a real estate class, let's make it specifically about real estate. Could a minor, somebody under the age of 18, and by the way, for those of you that have teenagers at home, you can tell them this and they'll love it. The state of North Carolina actually defines anybody under the age of 18 as an infant. That's what it says right in the statute. So those of you who have those 17-year-olds that think they know everything, you can remind them they're an infant according to the law. But those minors can enter into this agreement. Nobody is going to tie them down and say that they can't. The key here is that they can't be held responsible for that agreement. You notice there's a difference there, correct? What that means is that could a minor go through with a contract? Could they sign one and then could they go all the way to closing if we're talking about a real estate contract? Sure they could. Sure they could. Absolutely. But they could not be held responsible for. Remember, a contract is a set of promises, correct? They can't be held responsible for their promises. That's what it means for them to be a minor. They haven't reached that age where they're responsible for what they promised. Yes, ma'am, Sarah.
So at the signing of the contract, if they are under 18, but then, a year down the road, they turn 18, 19, whatever, and then can they be held responsible? Or is it at the time of signing, you were 17, so this contract is, we can't be responsible for it?
So Sarah's question is a good one. Basically, as I understand it, she's saying if the minor signs a contract when they're under the age of 18, when they are a minor, and then they become an adult at some point while the contract is still in effect, it hasn't been closed. Is that where you were going with that? They haven't closed the contract, but the contract still exists. So let's say they're a month shy of their 18th birthday. They're 17 and 11 months, and they sign a contract to purchase a piece of property, and then they turn 18 before closing. Could they then be held responsible? That's a really good question. It gets into the idea of have they done anything to sort of validate that contract after the fact that they were 18. They can't automatically be held responsible for a promise they made when they were 17, but if they show that they're still willing to continue to be bound by that promise after they're 18, then the law might say or hold that they are now of age and understand what they're doing. So it's not necessarily an automatic thing, but it's a really great question because it does happen from time to time. Okay? So what other things would make us legally incompetent? Mentally incompetent. And I like to joke, you can be crazy, but you can't be crazy with papers. If you've been declared mentally incompetent, then you cannot enter into a contract, or rather you cannot be bound by those contract terms. You can't be bound by those contract terms if you've been declared mentally incompetent. And then the last one, unlike our friend here who's had a rough night, I think, you cannot be intoxicated and be bound. This is one that I always point out to agents in the real world. Sometimes in CE classes and continuing education classes, we talk about this. It's probably not a good idea for you as a broker to meet your clients for drinks to present an offer to them. Because you've got this idea that an intoxicated person can't be held legally responsible for any agreement they enter into. Well, if you're watching them consume an intoxicating beverage, and Lord knows we all like a good drink from time to time, most of us anyway. Let's hold off on that. Let's wait until after we've presented the offer, after they've made a decision about what they're going to do with that offer. Because you don't ever want to put yourself in the position of having those folks be able to say, well, you know, I really didn't know what I was doing. I was intoxicated at the time. Does that make sense? So I think that's probably a good course of action for you guys. What other requirements do we have for a contract? We say that contracts have to be supported by legal consideration. Contracts have to be supported by legal consideration. So what is consideration? We always have to ask ourselves that. Well, consideration, for lack of a better description, is money. Something of value. Now, one of the most common misconceptions is that the money has to have already been exchanged in order for it to be a contract. That's just simply not true. If you think about it, folks, what comes first, the contract or the exchange of money in most cases? The contract does, absolutely. The contract comes first, not the actual exchange of money. Here's where I want to point that out to you as far as being a real estate broker and how that might create an issue for you. A lot of times you'll hear brokers say things like, well, you haven't yet made your earnest money deposit, so we're not under contract. We get that in the real world often. We've accepted an offer, sellers have accepted an offer, we've communicated that acceptance back to the buyer side. The contract calls for the buyer to pay an earnest money deposit within 5 days after we've gone under contract, and it's day 6 and the earnest money has not been paid. Well, now clearly, the buyer has not done something they promised to do, correct? Sometimes you'll get a phone call, or an agent, the listing agent, would place a phone call and say, well, you know, we're going to accept another offer because we never went under contract with you because you didn't pay your earnest money deposit. Here's a question I'd turn around for that agent in that situation. Why exactly is it that you think I was supposed to pay the earnest money? Because what's the answer to that question? Why do they think the buyer was supposed to pay that earnest money? Because it's in the what? As Devon said, it's in the contract. Well, if we never had one, then were they supposed to pay it? So you get into this cycle sometimes of thinking that consideration is earnest money or consideration is a due diligence fee. It's not, folks. Consideration is the promise of exchange of something of value. So in the case of a sales contract, what thing of value has the seller agreed to exchange? The seller, Micah said, has agreed to exchange property. And what is it that the buyer has agreed to exchange? Money. AJ said money. Cash. That's the promise of consideration, and that's what we need for a contract. Yes, Gray?
In that example, they're under contract, but would that not be considered breach of contract? So they could potentially accept another offer because of breach of contract?
So Gray's question is that he understands they're under contract, but could that be considered a breach of the contract, right? Yes. And the answer is absolutely. That could probably be considered a breach of contract. I don't ever want to say definitively because, again, I'm not a judge. I'm not an attorney. But in my opinion, that probably would be considered a breach. However, with most contracts, and this one is no different, a breach of contract is certainly something that we have to deal with. It doesn't mean we were not under contract. It just doesn't mean that we were not under contract in the first place. We still have a contract. And we have to treat it like we still have a contract. We cannot just declare we're going to accept other offers simply because somebody has breached the contract. There's got to be some process for working through that breach, and what are the penalties for a breach. Breach is a word that we're going to talk a lot about in this chapter as well. It means when one party has violated the terms of the agreement. But it doesn't automatically just, you can't just say, oh, you breached, I'm going and accepting another offer. Because the truth is you still have a contract, and you've got to work through the process for dealing with that breach. So don't just make assumptions when it comes to contracts either. All right? So we've got to have that promise of consideration. it also has to be something that's a legal act. The promises that are made have to be for something legal in the first place. There are plenty of agreements that get made and carried out that are not for legal acts. Somebody give me an example of one if you want. I know you all can think of something, some kind of an agreement that happens, some kind of a transaction that happens where the parties have agreed on a purchase price and one pays the other and they close that deal, that transaction, but it's not for a legal act. What is it? Give me an example. I heard it, finally. Mahogany said a drug deal. It's okay, you can volunteer. Nobody's judging. We were all thinking it, Mahogany. You just were the brave one to say it. That's exactly right. Is that an agreement? Is it a promise between two parties? And might they even be legally competent parties if they haven't been partaken already? But it's still not a contract, because ultimately what a contract refers to is, would a court of law enforce the agreement? Can you imagine if some drug dealer shows up and tries to sue the buyer because they didn't pay them for the product? What would a judge say in that situation? Tavon said, time to go to jail. Yes, after he got done laughing himself off the bench, or herself off the bench, I am quite sure that it'd be a bad day for both of the litigants in that case, wouldn't it? So there are plenty of examples of contracts where we just don't meet the basic definition of a contract because we're not performing a legal act. Yes, Adam. Oh, okay, just stretching. All right, so it has to be for some legal act. The thing you're promising to do has to be for a legal act, or it's not going to be enforceable in a court of law. We like to talk about this idea of express versus implied, an express contract versus an implied contract. In real estate, we like to always operate in the realm of express contracts. We want to be in the realm of express contracts. An express contract is one where the terms are clearly stated. Now, they can be stated either verbally or in written form. Which do you think we prefer? Written form, always. We always like to have written form when we possibly can. But we could have an express oral agreement. Later on, when we talk about agency agreements, for example, we'll talk about an oral buyer agency agreement. That's still an express agreement because we've clearly laid out the terms. Where we don't want to be, ever, in a real estate transaction is in this thing called implied contract space. We don't want to be sitting over there with an implied agreement. An implied agreement is one where our actions have dictated that we're going to be bound. Now, it's not that an implied contract is a bad thing. We do them every day. How many of you have eaten recently at a sit-down restaurant where you had like a table service, a waiter, waitress, server of some type? Most of us have. That was an implied contract. Nobody expressed the terms of your agreement with that restaurant. When you order the meal, they don't say, okay, well, if you order this, it's going to be $25.95 plus tax and gratuity, and you're going to be expected to pay that with cash or charge at the end of your meal. That would be an express contract. No, you order, you eat, and it's expected you will do what? You will pay, absolutely. And if you don't believe that contract, that implied contract can be enforceable, get up and walk out and see what happens. You'll find very quickly that that agreement can be enforced. So implied agreements can be enforced. You know, an example of an implied situation in real estate, for example, could be when you act like you have the power to do something that you really don't have the power to do. And that can get you in a lot of trouble because you end up with authority you're not supposed to have. So not only have you sort of done the wrong thing and put yourself in a bad situation, you also put yourself there doing it for free because you never had an agreement agreeing to compensate you for it. So be real careful with that. Make sure we always operate in express agreements and not implied agreements. So your book introduces this idea of a bilateral or a unilateral contract? A bilateral or unilateral contract? Well, let's take a look at what these things are. First of all, before I go into the detail of a bilateral and unilateral contract, let me point out something to you. Every party, or every contract rather, has two parties for your purposes in this class. When we say unilateral, and we understand that uni means one and bi means two, we're not talking about the number of parties in the contract. There's no such thing as a contract of one party. A contract with myself. I violate that every day. I say I'm going to go to the gym today. Well, there's a contract I broke, right? That is not a unilateral contract. It's not one party we're talking about. It's actually one set of promises. So, like our unicycler here, and by the way, I have somebody in my neighborhood who rides a unicycle. It's the weirdest thing you've ever seen. When you're sitting out in the front yard and you just watch somebody go by on it, it's like the circus come to town. And the better part is he actually walks his dog while he's doing it. I fall down looking at this. Like, I mean, I cannot even imagine the coordination it takes to walk your dog while you're riding a unicycle through the neighborhood. But he does it, not me. There's a kid in your school that rides one to school every day? That's awesome. More power to him. I can't do it. It would be a calamity like you've never seen if I tried to get on one of these things. I have a hard enough time with two wheels, so I'm not trying one. But like our unicycle here, there is one of something in a unilateral contract. It's promises. One promise. And specifically, one party bound to their promises. So there's two parties to the agreement, but only one of them is bound by what they've said they're going to do. And I use this example, an offer. An offer is a really good example of a unilateral agreement. Think of an offer. Generally speaking, when a buyer makes an offer, so if AJ has his house for sale and a buyer comes along and makes an offer on that property, has the buyer promised to do something? Sure. AJ said yes, they have, because he wants the money. They have promised to do what? What does the buyer promise to do? Pay, buy. Pay for his property, purchase that property from AJ. That's the promise they have made. Has AJ promised to do anything? Not at all. Not at all. So when we have two parties, and we still have two parties, there's a buyer and there's a seller. When we have two parties and only one of them is bound, only one of them has made a promise, we call that a unilateral contract. Because at that point in time, AJ has made no promise to do anything. So an offer is a good example of a unilateral agreement. Now, we of course would much prefer this situation, a bilateral agreement. In a bilateral agreement, both parties have promised to do something. So if an offer is a good example of a unilateral agreement, what's an example of a bilateral agreement? Tina said the sales contract. Once that offer has been accepted, now I heard some folks say counteroffer. That's not true though. Emily, what was that again? Emily said it changes it back to an offer again. A counteroffer is just an offer from the opposite side. It's like a ping pong match, right? A counteroffer is just an offer from the opposite side, because if AJ made me a counteroffer, sticking with my example, who's now bound in that agreement? The seller. AJ would be the one that's bound in that agreement. That's exactly right. Sarah said the seller would be the one that's bound. And she's exactly right, because the buyer would not be bound in that counteroffer. We can't make a counteroffer to a buyer and have them be bound. But if the buyer accepted that counteroffer, then we would have a bilateral agreement, because at that point in time, both parties have agreed to be bound. So both parties are now tied together with each other. That's a bilateral agreement, and that's where we would prefer to be, obviously, on any sales contract that we're part of or that we're helping to draft or put together in a transaction. We want both parties to be bound. We also get this terminology executed and executory. Is it an executed agreement or is it an executory agreement? And you notice I didn't put any pictures on this slide. Trust me, when you start Googling and trying to find pictures of executed or executory, it's not something you want to share in a classroom setting. It's like, whoa, I didn't even think about it. And that means you do too much contract law in general, right? When you think of those words as being contractual words, I was quickly reminded they refer to something else. But even as sort of rough as that is of an idea, it does help us understand. If you have an inmate that's on death row, are they executed or are they executory? They're executory. And the key thing is they're still on death row. They have not been executed. Contracts work in exactly the same way, folks. A contract that's been signed where the promises have been made but we have not closed is called an executory agreement. But once we close, once all those promises have been fulfilled, once the parties have gotten what they bargained for, what do we call it? That's an executed agreement. Good. Good. Very good. Does everybody understand the difference in that? Okay. And that's one of the most common mistakes we hear a lot in our business. It is almost like clockwork that you could expect, a phone call from a lender. And sometimes even from a closing attorney's office, which is sort of funny if you think about it. And they'll say, well, we understand you're under contract, on Mr. Smith's purchase. Can you send us a fully executed copy of the sales agreement? And I swear, that smart aleck part of me just wants to go, well, no, if I sent you an executed copy, it wouldn't be any need for you to have it because we'd be closed, right? But everybody gets that terminology a little bit wonky in the real world, but I want to make sure you guys have gotten it straight for test-taking purposes so that you understand which is which. And then we finally have worked our way up to the magic word. Is this an enforceable agreement? So what does enforceability mean? It simply means that if we ended up in a court of law, and why would we end up in a court of law over a contract? What happens? Well, a breach could end us up there. As Taman said, a breach. What else? How about people just sue each other, don't they? Don't people just sue each other? Even if there hasn't been a breach and somebody thinks there's been a breach, do you get parties that sue one another? Absolutely. So we end up in court inevitably when someone sues someone else. And here's why I say that. Could we have a breach that we don't end up in court over? Happens all the time. Happens all the time. People breach contracts and the other party doesn't want to go through the hassle of filing what? A lawsuit. Grace said a lawsuit. Exactly. And that's true. We don't want to go through the hassle in some cases. So don't assume that just because there's a breach, we automatically end up in court. Though breaches are the most likely reason we would end up in court. So what are we really asking ourselves when we talk about enforceability? Ultimately, what we're really asking is, would a court of law, and in our case in North Carolina, look at that agreement and say, yes, this agreement is real. These sets of promises were agreed to. They have to be followed. Because when I sue somebody over a contract, am I not really suing them, trying to get them to follow the terms of the contract in most cases? Or to pay me some money because they didn't follow the terms of that contract. That's what I'm suing for. I'm not just suing for my health here. I'm suing because somebody I feel has done me wrong. I mean, you think about all the lawsuits you've ever seen. Generally speaking, when you're talking about a contract, it's because one party feels the other party didn't do what they promised to do. They didn't pay me. I paid them, but they didn't do the job correctly. Those are all examples of why people might sue. And so when we talk about contract law, enforceable is the magic word. Now, let me caution you here. Enforceable has nothing to do with closable. Closable is not a legal word. I made it up. But closable is probably more important to us as real estate brokers. when do we mostly get paid in transactions? Not when have we earned our commission, but when do we mostly get paid in transactions? At closing. So closable is a magic word for me. And it'll be a magic word for you too once you get your license, because you want to get paid in these transactions. And the truth of the matter is this. There is no requirement that a contract be enforceable for somebody to close that contract, for somebody to live up to those promises. It doesn't exist. I don't want you to think of this as some sort of on-off, black or white choice. Contracts don't work that way. Enforceability only matters where? In a court of law. Exactly. It only matters in a court of law. It's an important word. It's a tremendously important word. But from your perspective, please don't be that person who shows up at a closing and says, no, wait, we don't have an enforceable contract. We can't close. Somebody's going to hit you with a brick. I can promise you. They will, because they want to get paid. And ultimately, if a buyer shows up with money and a seller shows up with a deed, what are we going to do? We're going to close. You all are exactly right. We're going to close. So as we go through these terminologies and we talk about, is this contract enforceable? What I want you to focus on in your mind is we're talking about, can this party be sued? Would a court of law find in their favor if they did sue? That's really what we're discussing here. We're not talking about closability. All these examples of things that are less than enforceable can certainly be closed. I mean, we'll go back to our earlier example. We said a contract to be enforceable had to be for a legal act. And Mahogany, I'm not going to let you forget it, reminded us that a drug deal would be something that was not for a legal act. Can that deal be closed? Can that contract be closed? Absolutely. It happens all the time. It happens, not that I'm speaking from personal experience, but it happens all the time. So don't confuse enforceability with closability. Fair enough? All right. So we want to talk about what makes a contract enforceable, and of course where they're enforceable, which is in a court of law. And to do that, we have some words. There are 4 different categories of words, and they are going to be tested. You're going to have to learn how to identify them on a test. So I would suggest that you really, in your notes, start to pay attention so that you can get these terminologies down for the exam. So the first one is valid. A valid agreement. From our perspective as a broker, this is the best type of agreement that we can possibly have, because a valid agreement is enforceable on both of the parties. A valid agreement is completely enforceable on both parties. We don't have to pick and choose and say, you know, oh, it's only enforceable on the buyer, or it's only enforceable on the seller. In this case, which party has the right to sue the other party if things don't go well? Both of them. Both of them. And so what I would mean in a valid contract is if the buyer doesn't do something they promised to do, could the seller likely go to court and ask for some relief from that? Ask for a court to enforce the contract? Sure. And on the flip side, if the seller doesn't do something they promised to do, could a court of law be asked to enforce that contract on the seller? Absolutely. That's valid. When both parties are bound. So to get there, we've got to have all those things we've already talked about. We've got to have legally competent parties. They have to have that meeting of the minds. There has to be consideration. All those things have to be in place to have a valid agreement where they're both bound, where both parties are bound. That's a valid agreement. Now, one that comes up often for us is the idea of a voidable contract. Now, a voidable contract is one where only one of the parties is bound. Not both, just one. Sometimes we start out as voidable, sometimes we start out as valid, and we get to voidable. Look at this picture here. And I love the fact that he's signing this with a crayon, by the way, in case you hadn't noticed. I think that's the best part about it, is that he's signing this contract with a crayon. This is an example of a voidable contract being formed. What's wrong with this picture? There's a minor signing it. That's exactly right. There's a minor signing this thing. That is exactly the problem that we have here. And ultimately, that creates a voidable contract. Voidable means only one party is going to be bound in that transaction. Well, if you look at this picture here, which one would you think is going to be bound by this agreement? The adult, right? The adult is going to be bound. This gentleman right here, who's conveniently pointing out where to sign, of course. You know, when you make contracts with 5-year-olds, you kind of have to tell them where to sign. So, who's not going to be held responsible for their promises in this agreement? The signature in crayon sort of gives it away, doesn't it? The minor. The minor in this case is going to be able to back away from those promises. They're not going to be bound by those promises. The interesting thing here, is the adult bound by his promises? Absolutely. That's what we mean when we say a contract is voidable. One party is bound and the other party is not. And that's exactly what you get when you get a contract with a minor. Not only contract with a minor, a contract with an intoxicated person would also represent this case where you had a voidable contract. And in that case, in the case of an intoxicated person, who would be held responsible and who would not be held responsible? The drunk person, the intoxicated person, as Mahogany said, would be not held responsible. And what about the sober person? They would be held responsible. That's exactly right. The one who's sober would be held responsible. So anytime you're talking about one party being responsible or it being enforceable on one party, that's called voidable. Now, we can also get to voidable from valid. We could start at valid and then end up in voidable. The breach. A breach of a contract could create a voidable contract. So let's think about that for a second. Sorry, Adam, go ahead.
So with the voidable of a minor, so what if you did go under contract and later on the seller finds out that it was a minor and he wants to break contract? They would be forced. I mean, so the minor could sue him in court to actually sell the property later on, couldn't they?
Sure. So Adam's question is, what if a minor does enter into that contract? What if the minor signs a contract to purchase and the seller is an adult? The seller later finds out that they're under contract with a minor. Maybe they didn't know. Maybe that, they assumed that this person was an adult. I mean, the seller may not be asking for ID when they're accepting an offer on their property. Is that reasonable to expect, right? We probably, in fact, is it reasonable to think that the seller may never even see the person who's buying their property? Absolutely. That happens all the time. So, in Adam's question, let's say the seller is just unaware that they have entered into a contract with a minor, but they find out, a week later, they find out, nightmare scenario. The buyer is 17 years old. And the seller wants out. That's what you were asking. The seller wants out. What do we do? And what is the best avenue forward? And then his follow-up question was, couldn't the buyer still force the seller to stay around? And the answer to that follow-up question is yes, because no matter what the seller knew, they still entered into a contract knowing that they wanted to be bound. And they're an adult, so they're going to be bound by that promise in most cases. Does that make sense? The seller is going to be bound by their promises because they're old enough to know. It's the minor who would not be bound. And then his follow-up question was, theoretically, could the minor still sue the seller and force the seller to go through with the contract? Well, is the contract enforceable on the seller in that case? Absolutely it is. And so, in theory, could the minor sue the seller and force them to sell the property to them? Yes. That's what voidable means. Voidable means one side is still bound, but the other side is roaming free. And a contract with a minor creates that. The breach also creates it. So let's give an example here. Let's say that Micah is selling his property and Brandy is buying the property from Micah. And as part of the negotiations, Micah agreed that he would repair the deck on the property. There's a couple rotten boards on the deck, and he agreed that he would make that repair. Everybody following so far? So, comes to the day before closing, and Brandy is doing her walkthrough of the property day before closing. Micah's moved out. Brandy's excited. She's going to do the walkthrough, make sure everything looks good. She's already got all her stuff on the U-Haul truck sitting out in the driveway. Dog sitting in the front seat of the U-Haul truck. I mean, this is the real world, folks. This is how it happens. You know, I've always often wondered about that buyer in that situation. Why are you even coming to the walkthrough? Because presumably you come to the walkthrough to make sure it's okay, because if it's not okay, you're not going to do what? Close. If your whole life's packed up in a U-Haul truck in the driveway, you've sort of given away that you intend to close, right? So maybe you caution buyers against being that overly anxious. But in this case, Brandy's all packed up and she's sitting out in front of the house, and she comes to do the walkthrough. And she sees that the deck boards are not replaced. Has Micah breached that contract? Yes, he has. You're exactly right. He has. Micah has breached that agreement. He did not fulfill his promises. So that becomes, or could become, depending on the terms of the contract, what kind of contract? A voidable agreement. Who now has the right to walk away from that picture? The buyer, Brandy does, because the promise to her was broken. Does that make sense for you guys? The promise to Brandy was broken. And so she has the opportunity to walk away, and there's nothing Micah can do about that, because he started that chain of action-reaction by doing what? By not fixing the boards. Sarah said he didn't fix the boards. Simple as that. He promised to do it, and he didn't do it, and that breaking of a promise created a voidable situation, a breach. Now, let's circle back to what I mentioned before we started down this road. Can Brandy still close that transaction? Yes. And is it very likely that she probably will, quite honestly? Because her choices are not great choices at that point in time. She can back away and say, I'm not buying your house. You breached. You have not fulfilled the promises. But then she's got her whole life packed up in a U-Haul truck and nowhere to go. So realize that ultimately sometimes as real estate brokers, even though it's voidable, that doesn't mean that's our best option. We usually want to try to reach some sort of compromise in a situation like that and get it worked out, because obviously having her not close is probably not in anybody's best interest, and that would be her included. But she would have that option. That's what we mean by voidable. All right? And obviously, as we've mentioned several times, anytime we've involved a minor or an intoxicated person, that would be a voidable contract. They do like to ask about those specifically on tests. So specifically, I would make sure you go back and reference that contracts with minors or contracts with intoxicated persons, contracts with somebody who's mentally incompetent, those are all going to be voidable contracts. We started at valid. Valid was enforceable on how many parties? Both. We went down to voidable. How many parties were enforced in voidable? One. Where do you think we're headed? None. Tavon said none, and he's right. So what is an unenforceable contract? By the way, this is not the expression you want to see on a judge's face if you ever end up in court. If you're on the other end of that, then you're probably not having a very good day. But an unenforceable contract is there is no legal agreement any longer. If there ever was one, there is not one any longer, because neither party is bound. There's nothing tying them together any longer. The agreement itself is not enforceable on either one of these two parties. So let me ask you, do you think we could have started as valid? Could we have started at valid and worked our way all the way down to unenforceable? Sure. How would that happen? So Taman's got an interesting one over there. We've got bars and drunk people and all kinds of things thrown in there. He said we go to a bar, we get drunk, everybody's drunk. That could be unenforceable. Maybe both the buyer and the seller. Be a heck of a party, but it might be an unenforceable contract, correct? How about if we revisit the Micah and Brandy situation? He didn't fix the decking boards, so she's upset with that. Now she has promised that she would lease the property back to him for 3 days after closing. So she goes over there and she sees the decking boards aren't fixed, and what does she say? She's not leasing it back. We'll close, but I'm not leasing it back to you. Now who violated a promise? Both of them. Micah violated a promise about fixing the deck, and Brandy violated a promise about leasing the property back. Does that make sense? So if they've both broken promises, which one is our friendly judge here going to look at and say, you're bound by this contract? Neither one of them. Neither one of them. That could be an unenforceable contract. And it could have even started as valid. We could start at valid and work our way all the way down to unenforceability, like with a breach by both parties. That would be an example of creating an unenforceable agreement. And then the last one, a void contract. Now, void and unenforceable are not the same thing. They have the same legal impact because when we were back here at unenforceable, we said which party was bound. Unenforceable, how many are bound? Neither one. Good. Neither one. Same thing's true here in void. In a void contract, neither one of those parties is bound to act. They don't have to do anything. But it's not the same as unenforceable. Because in unenforceable, they at least promised to do something that was legal. A void contract never was a legally enforceable agreement because it never met some basic definition of the law. Like, for example, it was for a legal act. So if we circle all the way back to that illegal substance transaction, that drug deal, that's an example of a void contract. A void contract never was a contract at all because it was for something illegal, for example. You never could have had any enforceability. The reason it's not enforceable on either party is because the thing they were trying to agree to do just is not allowed. Does that make sense for everybody? Good. Let's find out how much sense it makes. I have a little exercise. Don't groan. It's not that bad. I need 2 volunteers, please. And I promise it's not like a magician's act. I'm not going to saw anybody in half. All right. So Tavon and who else? Nobody else? Really? Really? Nobody else? I need 1 more volunteer. Come on. It's not that bad. I promise. You're not going to be asked any questions. All you have to do is stand up here and look pretty, and that's easy. Well, all right. Good. All right. So we're going to talk about valid, void, voidable, unenforceable. I promise you're not getting married. This is not what's happening here. I know it's a very frilly ribbon here, but I promise not. So this is an agreement. This is a contract. Would you agree it can tie them together? Absolutely. So let's talk about an offer. Let's say we're making an offer to purchase here. In an offer to purchase, are we enforceable? Has one person made a promise? Somebody's made a promise. But only in what? How many directions? One direction. Is that a unilateral agreement or is that a bilateral agreement? Look where the other end of the agreement is. That's a unilateral agreement. If Tavon accepts that offer to purchase, what kind of agreement do we have? A bilateral. And here's how we know it's bilateral. Promises have been made in both directions. Correct? And what other word would apply to this situation? A V word. Valid. Chris said valid. Exactly. A valid agreement. And here's how I know it's valid. Enforceable on the buyer. Enforceable on the seller. Are they both tied? Are they both bound by this agreement? Does everybody agree with that? Here's the interesting thing about a contract, folks. They tied themselves up in this. But once you tie yourself up, you cannot untie yourself. Tavon can untie a knot, but it's not his own knot that he can untie. Which knot can he untie? If Tavon is the seller, whose knot can he untie? The buyer's knot. Does that make sense for everybody? So let me give you an example of that. Let's say, in our valid agreement here, Tavon promised that he would replace the water heater as the seller. So the agreement is that buyer has asked for water heater to be replaced, and seller agrees. And we've got a valid contract, which means it's enforceable on which party? Both. Tavon does not replace the water heater and makes it clear that he's not going to replace the water heater. What happens with our valid agreement?
It's no longer valid.
It's no longer valid, as Tavon said. So show me what no longer valid looks like. I'll give you a hint. No, you can't untie your own knot. No. He's got to do it for you. He is releasing you. Now, hold on to it. Don't let it go yet. And here's why I say hold on to it. You may not want to let it go. Correct? What kind of contract is this? No, it's still a bilateral agreement because we've gotten there, but with a V word. Voidable. And here's how I know it's voidable. Is it enforceable this way? Yes. Is it enforceable that way? If Tavon went to court and sued that buyer, that's the same as tugging on the agreement, right? When he tugged on the agreement, what happened to it? It went away. It's not enforceable on that end. It's enforceable on this end. No matter how hard you pull, he's going to follow you around like a little puppy dog because he's tied to it. But now our seller is not tied. Why did I tell him to hang on to it? Because he may not want to let go. See, the thing about voidable is it's still an agreement, but it's an agreement that only has teeth on one end. Does that make sense for everybody? There's only binding this way. Could we still close? That's why it's in his hand still. He has the option to choose whether or not we go forward with this. Does Tavon have the option? No. Tavon's bound. That knot's still there. He's bound. That's voidable. Bound one way, not bound the other way. Is everybody with me? So what would unenforceable look like? You've got to untie his knot too. So give me an example of that happening. Now hold on to it. Don't let it fall. Give me an example of what could have caused that. So we'll stick with the same thing. Tavon did not replace the water heater. You breach. So what kind of breach? What do you want to do? Be a lawbreaker. Be a rule breaker. What do you want to do?
I didn't deposit the earnest money.
He said he did not deposit the earnest money. Would that be a breach as well from the buyer's perspective? Absolutely. So that unties Tavon from. So now here's what we mean about unenforceable. That's what this would represent. Unenforceable. Do we still have an agreement? Yeah, it's a saggy agreement at this point, but it's an agreement, right? It's still there. It's hanging on by a thread. But if either one of them decides they don't want to go through with it, so let's say Tavon decides he doesn't want to go through with it, and then we want to pull from this side, we want to sue, what's going to happen? That he's not bound. That's exactly right. That's exactly right. He's not bound to act. And if this alternative way happened, if Devon wanted to sue for performance and we go to court and we pull back this way, what happens? It just releases because neither one of them are bound to act. That's an unenforceable agreement. So with valid, who's got knots on? Both of them. With voidable, who's tied in the knot? One. With unenforceable, who's got the knot? Neither. They may still be holding the agreement, but they don't have the knot. Is everybody good on that? And void? In void, this never was. This thing never even came into the picture because we never could have possibly had an agreement between the two of them because it was for something that wasn't allowed. Thank you. I appreciate it. See, I promise it was not that bad, right? Yes, ma'am, Mahogany. No, that's okay. Okay, so Mahogany's question is, when it's unenforceable, it's not valid, and that is exactly correct. Because valid is a status. Unenforceable is a completely separate status. It's like saying, are the lights on or are they off? Can they be on and off at the same time? No. So, if it's valid, how many of the two parties are bound? Both. If it's unenforceable, how many of the two parties are bound? Neither. So can it be valid and unenforceable at the same time? You got it? Good. Good. Does anybody else have a question about those four statuses? Because they will probably show up on the exam. So I want to make sure. Yes, Devon, go ahead.
So I'm thinking unilateral only really be for no, if the status doesn't work with bilateral.
So Devon's question is, these statuses, valid, voidable, void, unenforceable, don't really apply until we get to until we get to a bilateral agreement. And he's exactly right there. Because in the case of a unilateral agreement, obviously we can't get to valid because only one party has even made a promise at that point. We have to get to the point that at least both parties have made a promise before we can start to describe these things as valid, voidable, void, or unenforceable. Go ahead, Adam.
Just want to clear something up quick.
Sure.
So an oral agreement between two parties, it's considered a void contract, right? Because it's only verbal, because it's not written. So for the oral agreement, it's because it's not written out that it wouldn't be enforced on either parties, but they still could exchange in the transaction. Like they could still, or buyer, seller, they could each, like the buyer, buy the property from the seller.
Sure. Can I ask one follow-up just to make sure I know exactly where you're coming from?
Right.
Are you talking about a sales contract for real estate?
I mean, yeah.
You said buyer and seller, but I just want to be clear you're talking about a real estate sales
Right.
contract.
So say that, like, I had a friend that wanted to sell me his property, and I said, yeah, I agree, I'll pay you this much. We didn't write anything out. That's a void contract, right? Because, I mean, it's not written. If we were to go to court, neither one of us would be bound if one of us didn't perform, correct?
So now I've got your question. So Adam's question is this. If I have a real estate sales contract and it's oral, well, first of all, is that a problem? And why is that a problem? And that's why I wanted to make sure you're talking about a real estate sales contract. The statute of frauds, I heard it several times, and I heard AJ say it was because it had to be in writing to be enforceable. That's what the statute of frauds says about real estate sales contracts, correct? In order to be enforceable, they have to be in writing. So, his follow-up or his question, now that we've clarified that, was Adam wanted to know is that a void contract? Close, but not quite. It's not void. It's unenforceable. Okay. Remember, void means the thing that they were agreeing to, which in this case is selling the house, would be for something illegal. It's not an illegal thing to agree to sell the house, but it would be unenforceable because the statute of fraud says that to be enforceable, a real estate sales contract must be what? In writing. Good. That help?
Yep.
So you were exactly on the right thinking, just difference between void and unenforceable.
Unlawful and then enforceable, even though it was lawful.
Exactly.
It just wasn't.
Exactly. He said void means it was for an unlawful act. Unenforceable just means it can't be enforced, but they aren't really breaking the law. In other words, nobody's going to show, the police are not going to show up at that closing and shut it down just because they didn't have a written purchase agreement. I'm sorry? Absolutely. Tina said they could complete the transaction, and they certainly could. That's exactly. As long as, and Tina's follow-up was, as long as nobody had any issues, and that's the key. The key here is, if they are going to show up at the closing, if everybody is agreeable about how this thing is going to be closed out, then we're going to have a closing. Enforceability only matters when something goes wrong. When somebody feels like they've been slighted in the transaction and they do what with the other party? They sue them. They sue them. That's where enforceability matters. Okay? How do we feel about that? Good. All right, let's take a break then, and we will come back and finish up this chapter.